welcome to the stage for the first presenter of the day, Ryan with Burn the Corporate Fiction.
Yeah. Oh, watch out.
Good morning, ladies and gentlemen. Welcome to the second day of the International Truth Expo. It's good to see you all here. I'm Ryan, the creator and host of Burn the Corporate Fiction. Before I begin, let me give a big shout out to Carol for just a phenomenal setup. And she has to be somewhat of a genius to be able to think of everything and coordinate so many different schedules to pull this off. So let's give her a round of applause. And secondly, I'd like to give a shout out to my wife, Michelle, in the back there, because there would be no Burn Corporate Fiction. So, very good to see all of you here. I'm going to be doing somewhat of like a live stream presentation, if you will. We're going to wing it because there's a lot to cover, and I never know what I might not think of in the moment, so I have this accessible. But let's begin with this. How many of you, by a show of hands, believe you own your house? Then why do you still pay for it? Why do you pay the state for it? Think about that. How many of you think you own your automobile? Why is the state's name on the back of it? Why do you have to pay for permission to use it? Why do you have to have a license, right? Think about these things, because at one point in time, this republic was 100% free. The greatest misconception that people have when it comes to the law is that when we became independent of England and the crown, that we created a new law. We were like, hey, we have this new republic, right? What kind of law should we have? Most people never think about that, but we did not create the law. In fact, there is only actually one law. It's called the common law. The Romans, the Pope calls it jus commune, which means common law, as opposed to jus particulare, which is private law. I'm going to try not to bore you guys with the specific terms, okay? But let's take a look at what is common law. This is a treatise called the Heart of Blackstone. It's actually a treatise on Blackstone written by a professor at Washington University in 1905. Her name escapes me, but if anybody wants to know after, I will definitely show you. She says the common law is grounded upon the general customs of the realm and includes in it the law of nature, the law of God, and the principles and maxims of the law. Okay, these are universal. It is founded upon reason and is said to be the perfection of reason acquired by long study, observation, and experience and refined by learned men in all ages. Did anybody see in there where it says man created it? No, because man does not create law. There's a default law that pre-exists even sovereigns, right? Even the crowns of Europe. There's a law that everyone is subject to fundamentally, and it's called the common law. And it's founded upon the law of nature, nature's God, divine revelation, Mosaic precepts, and yes, it all does go back to the Bible. Even Brandon Joe Williams, which I'm sure many of you have heard of, and I have no problem with the guy, I disagree with his tactics, but that's whatever. And he even admits that all this law, especially trust law, goes back to the Bible, because there is only one law. It's unwritten by man, it's observed, it's written about, and it's applied to society. And its application to society is called common law. You can sum it up simply as this. Do not violate the free will of another and honor your word. It's the source of contract law and why every single constitution in every single state in this republic has no state shall pass any law impairing the obligations of contracts, or no law shall be passed impairing the obligation of contracts. And this is how the elite gets you. By the end of this presentation, you will see that this is actually a satanic plot to usurp divine jurisdiction and enslave you permanently in a digital prison with a digital ID and digital currency to bypass due process, so that say you're driving in your car and you decide the speed limit's 55, you decide to go 60, right? Well, ordinarily, a cop would pull you over. He'd try to create an attachment to the public trust via your identification, your driver's license number, license plate, whatever. I'll get to that, it will make more sense shortly. And then you have to go to an administrative hearing, and the judge has to get you to agree to be that individual that's on your license, right? Which is actually a trustee, and I'll explain that in a little bit. That's how it works now. What they want to do, because of people like me, right, and there's quite a few of us out there, They want to make it so there is no opportunity to challenge jurisdiction. There is no ability to say, hey, my property's not under administration. I'm not collateral for the public debt, and you have no ability to regulate my use of my property. They don't want that. So what'll happen is you're driving 60 in your smart car, and it'll notify the AI governance that they're interested in setting up. Right now, they are setting up right now, like Gideon, for instance, if you've heard of it, the Israeli one. And it will automatically deduct whatever the fine is from your digital wallet. And there will be no due process. There will be no state your name for the record, right? None of that. So, before you can understand why that's wrong and how satanic it truly is, you have to understand what the law is. So we see this is a very good but brief description of common law. And like I said, this book's called The Heart of Blackstone from 1905. And so we'll go to Blackstone himself to see what he has to say about law. Okay? He says, the law of nature being coeval with mankind and dictated by God himself. Now think about this. This man, his full name is Sir William Blackstone. Okay, he was a knight. Now the definition of Templar in an 1828 was 1828 Webster's dictionary, which was the dictionary for common law before Bouvier. He defines the law, hold on, I'm sorry. This, yeah, I think I got the right thing up. Yeah. Okay, Bouvier, or Webster 1828 dictionary defines Templar as a student of the law. That's where I was going with that. Anyway, defines him as a student of the law. Now, all attorneys, bar attorneys, are esquires. Esquire is a title above a nobleman, but below a knight. And actually, the 1828 Webster's definition of that is a shield bearer and attendant to a knight. So imagine how good of a jurist William Blackstone must have been to actually be a knight, a student of the law. And he says, the law of nature being coeval with mankind and dictated by God himself is of course superior in obligation to any other. It is binding over all the globe. Yeah, he believed it was a globe, whatever. Anyway, it's binding over all the globe, in all countries and at all times. No human laws are of any validity if contrary to this. This is where you get Supreme Court rulings like Marbury versus Madison, where they say any law repugnant to the Constitution is null and void. Well, it's not actually law. See, man cannot create law, like I said, so they always have to call it something else, like statute, code, canon, as the Pope likes to say. And he said he didn't want to offend the kings, that's why he calls it canon. But the kings don't call their laws either, they call them statutes. And so even to this day, when they try to deceive you and pretend like what they're doing is law, they have to put some prefatory statement in front of whatever type of law it is. Civil law, administrative law, trust law, contract law, those are all private. Agreements between two people. Absent any agreement or dependency, this is the law you're subject to. In all laws that you're generally subject to, if you live in a city or a town or whatever and they want to write statutes, it has to be in accordance with this law. So, he says that no human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately or immediately from the original. It's the only way it can work, right? So, we go down a little further, sorry about that. We go down a little further, and he says, upon these two foundations, the law of nature and the law of revelation, so that is the basis of actual law. So imagine, absent any type of government whatsoever, okay? Absent any type of government whatsoever, what law are you under? You're under God's law. You have no choice, right? And that gets into dependency, which we'll cover here shortly. But even in Cruden v. Neal, which is an early Supreme Court case, right? And I know it's hard to see because it's over here on the side. They really tried to hide this one, but still, CaseMine is an AI-driven lawyer's resource tool. And it says right here that and I'll highlight it for you, that the majority shall prevail is a rule posterior to the formation of government and results from it. It is not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Now this case is interesting and it applies to us very much. See, what this was a British loyalist, and when the Revolutionary War broke out, he decided to remove himself from his state with the colony, which state is just a state of being. That's all that ever means. You say corporate state, police state, it's a state of existence. That's the word state only means that. And that's another confusing thing for people. But anyways, he decided to side with the English. And afterwards, they tried to hold him accountable for being a traitor. And the justice, which I believe it was John Jay, but I'm not 100 on that, but the justice gave an absolutely excellent opinion. And he said, listen, there was no United States when he decided to fight with the British. In fact, it was called the American Civil War all the way up until after the Second Civil War. They called that the Second American Civil War because this one, it was British against British. And he's saying he could not possibly be a traitor to the Republic because there was no Republic. We were fighting to create the Republic. And so, by siding with the English, he was actually just being loyal to his king. And so we cannot hold him accountable. The reason I bring this up is because it says prior to the creation of any government or any situation in society, right, there has to be consent among the people who are going to be governed to agree to live in this society, in this sort of situation. So, when we became independent, we didn't create a new law. What changed, that common law that I was just showing you, which applies to sovereigns, and it's the law of nature, nature's God, we just continued using that with one big change. We were no longer subjects of the crown. And so we were literally sovereign, 100%. We'll pop over here to Chisholm v. Georgia. And you'll see this. This is 2 U.S. 419, 1793. This is going to tell you the relationship that the people are actually supposed to have with the government. Okay? It tells you, let me see if I can find my cursor here. All right. At the Revolution, the sovereignty devolved upon the people. And they are truly the sovereigns of this country, but they are sovereigns without subjects. Unless, obviously, we had slavery, right? And they still were hesitant to call those subjects. And there's actually a much deeper and interesting history about slavery. I'm not going to digress too much into that, but what they don't teach you in school is important, that the actual infrastructure for slavery was built on the backs of the Irish indentured, not to take away from the suffering of the Africans, because they absolutely did. But that's one of those lies or one of those facts that they omit to make sure they can engineer division among the races, and we don't actually rise up against the people who are screwing us all over. But that's enough digression. The sovereignty devolved on the people, and they're truly the sovereigns of this country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Think about that. So, he goes on to explain, from the differences existing between feudal sovereignties. Now, feudalism. What feudalism is absolute government control of all property and labor, where the people are reduced to property. And that way, they can take you to a court of equity, which will actually make more sense shortly. But feudal is essentially what happened in 1066, and I thought about giving you guys the deep history, but I don't think I have enough time. 1066, prior to William the Conqueror, all English people, all Britons, held their titles allodially. Who knows what allodial means by show of hands? Anybody? Okay, fantastic. It means free of any superior claim. The funny thing is, in Leviticus, God says, the land shall not be sold forever because it belongs to me, and you are just foreigners and sojourners in my land. Allodial actually represents a covenant between God and man. It comes from the Old Norse othala, which means all oath. And what you did was you made a covenant between the land and God to be a good steward and have dominion over a specific section of land. I can prove to you that all lands in this country are actually allodial. This is the Wisconsin 1848 Constitution. Article 1, Section 14, which of course most old documents like this are photocopied because, well, it's old, but Section 14, if you can see it, there's my cursor. All lands within the state are declared to be allodial, and feudal tenures are prohibited. Okay, so now that we've got that down, the definition of allodial, let's get back to the point. So, William the Conqueror, before he came over, all the Britons held their lands allodial. You have to learn this little bit of history to understand what's going on here, because we inherited everything that was developed from William the Conqueror onward. The Set the KV Act, how many people know about that? Declared dead at sea. Okay, we got one person. Well, I can make that make sense, all right? And they do use that. actually, and the straw man is actually a thing. I hate the term. It's a buzzword for cops. It makes people think you're a conspiracy or you're a sovereign citizen, right? Well, actually, yes, it is a contradiction in terms for most countries, but here, as we are reading in Chisholm v. Georgia, the citizens actually were sovereign, the state citizens. So they created their own class of citizenship, the federal government did. We'll get to that shortly, called the U.S. citizen. But anyways, feudal tenure. So William the Conqueror conquered England, okay, but he let them keep their common law, took their military law away from them, their ability to mount a defense, and military law is a valid form of law because war has existed since man has existed, so, but it's supposed to be a temporary state for the common defense of whatever realm. He took their military law and said, you can keep the common law, okay, but you can't mount a defense. I personally think, and Blackstone writes about this, that he encouraged Denmark to invade England. And after invading England, they occupied for a little bit, then left. And William the Conqueror came back and he said, oh, that probably sucked, didn't it? You guys were occupied by Denmark, that was pretty rough. Well, I'll tell you what, I have this system of law that will protect you from future invasion. It's a military style of law. And we're a neo-feudal society right now. And by the end of this presentation, you'll see what I'm talking about. And he said, here, register all your land in this survey book. It's called the Doomsday Book. You can look it up, Doomesday book, right? Doomsday, spelt Domesday. Register, the word register, the original Latin regis means to the king. Regnatum means to be governed. Register means to give to the king. So whatever you register, including your children, you're giving to the crown. You're giving administrative control of it. So what did he do? And this is exactly how it works today. When you register your car, when you register your child, right? What they do is they go, okay, we'll take administrative control of this and we're going to gift it back to you in a feudum or beneficium, which is a trust. So they gift it back to you in trust, and now you only have the equitable right to use the thing or raise the thing, but you have to use it, right? How you're told to by whatever administrative agencies, which then at the time, obviously, agency is an old word, it just represents somebody doing something on behalf of somebody else, but it was the king. The king took administrative control of all the land and then gifted it back out to the nobles under different titles. And since man cannot make law, this style of governance is essential for man to enforce his will upon other men under the color of law. Because man cannot create law, but man can definitely determine how his property is used by another. You can. So when he took control of all the land, everyone in the nation needs the land to survive, must live on the land. He now could enforce his will through statutes upon other people under the color of law because it's on his property. And that's ultimately what they've done here with us today. So that little brief explanation is why it says, the differences existing between feudal sovereignties, see, the founders were very careful to set up safeguards against exactly what's happened today. And the governments founded on compacts, right? Difference between feudal sovereignties and governments founded on compacts, it necessarily follows that their respective prerogatives must differ. And I know this is a bit dry and boring, but I'll get to the more sexy stuff towards the end of the presentation of how it actually applies to you, because you know, the truth isn't as sexy as the lie. I'm not going to tell you there's a silver bullet for this, because there's not. All right? On Burn the Corporate Fiction, I teach people how to fight back. And the only way that you can fight back is by knowing what they're doing and being able to be such a big problem for them that they have no choice but to get you out of their courtroom because they don't want the other slaves to figure out exactly how this works and that they have no right to do what they do, ever. You hurt somebody? I can't help you, because that's actually breaking the law. But anyways, the difference between feudal sovereignties and governments founded on compacts, it necessarily follows that the respective prerogatives must differ. Sovereignty is the right to govern a nation, or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty generally is ascribed to the prince. Here, it rests with the people. There, the sovereign actually administers the government. There's that word administer. Okay? Administer always is related to a trust. When something is being administered, it is a trust. And that's what feudalism is, the entire national trust, reducing everyone to a national trust. Anyways, Here it rests with the people. There the sovereignty actually administers the government. Here, never in a single instance. Our governors are the agents of the people, and at most, now listen to this is important, and at most stand in the same relation to their sovereign in which the regents in Europe stand to their sovereigns. They're our subject. The fact that they ever presume to tell you what to do with your child or any of your property is insane. The founding fathers are rolling over in their, well, the ones that weren't actually a part of setting this up, because I'll get to that a little bit later, but the ones that were true patriots, like Thomas Jefferson, Patrick Henry, Thomas Paine, the ones who are the only reason we have a Bill of Right to the Constitution, are rolling over in their graves right now. You know, Thomas Jefferson said this, and I'm a firm believer. He said, "The tree of liberty must be refreshed from time to time with the blood of patriots and tyrants alike." I think that tree is thirsty. But I'm not advocating violence. Anyway, so he says, "Their princes have personal powers, dignities, and preeminences. Our rulers have none but official, nor do they partake in the sovereignty otherwise or in any other capacity than as private citizens." So when these people enter office, any office, a sheriff's office, mayor's office, governor's office, any office, they are indentured. They are now in a trust office and subject to our administrative regulation. How did they flip the script? How did they flip the script? That's the question, right? So, let's move over here. So here's the Bill of Rights of Virginia, just to further emphasize what, it takes a minute to load Hate Thee Trust, but let me tell you something. Hate Thee Trust, big shout out to this website, because without this website, a lot of good historical documents would be lost. They photo scan it. So this is the Declaration of Rights made by the representatives of the good people of Virginia. It says, number 1, that all men are by nature equally free and independent. It sounds like Blackstone, doesn't it? It sounds like everything we've been talking about. And have certain inherent rights, of which, when they enter into a state of society, they cannot, by any compact, divest or deprive or divest their posterity. Well, look at that, right there, the birth certificate's null and void. Your mother registers you. That's a compact. They can't deprive you of your rights to property, okay? They cannot. So this is an important point, right? Well, here, let me cover this too, that all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them. All right, that's important. So, what are rights? Let's talk about that for a second. What are rights? Well, right is something that's recognized to be universally good and true. Okay? But what most people do not know is that all rights are derived from property. Okay? Your rights are derived from property. Your relationship to your property determines your rights. If you have absolute ownership, then you have the right to apply lawful rights. When the state tries to seize or impound your vehicle, that's theft. Under law, that's theft. But if you're an infant under administration, which I'll get to here shortly, then it's not. It's just regulating the use of property held in trust. And that's the fine line that they like to walk. So rights are derived from property, okay? And your interest in property is called an estate. The Latin word for estate is status. Okay, so your relationship to your property is your status. You guys all heard, you know, you gotta correct your status, I'm sure, if you're interested in the law and the tax sovereignty movement, right? You gotta correct your status. Well, what that means is you have to correct your relationship to your property. Do you have absolute interest in your property, or does somebody else have an interest in your property, a superior interest, and they just let you use it? So this feudal system gave birth to a new jurisdiction of jurisprudence, we'll call it, but it's not law, and it's called equity. How many people have heard the word equity just used excessively over the last 5 years? How many people have heard the word equity? How many people know what equity is? That's exactly right, and they just say that dumb stuff to people knowing they don't teach you in school, and it's none of your fault. It's none of your fault that you do not know. They intentionally keep you ignorant of this knowledge that I'm presenting to you, because if you knew it, they would go to the gallows immediately. Okay? What equity is your interest, the privileges granted to you by contract in some piece of property. So you have ownership, and then you have equitable interest. Ownership is absolute allodial ownership. Equitable interest usually results from a trust, and that's where the jurisdiction of equity arose. The parents of a trust is fear and fraud. It's meant to remove personal liability and gain administrative control of other people. That's actually from a treatise. I didn't bring that up, but that's in the 1800s. People knew this stuff, that only God creates law, and that the only way that man can enforce his own personal will upon somebody else is to enter into some sort of trust relationship with them and make them the trustee / beneficiary. Because a beneficiary, how many of you here think beneficiary has power? How many of you heard you want to be the beneficiary of your estate? See, that's that garbage that people who don't actually study the history of law, and it's not your fault. There's a lot of compelling people, and I'm not going to name any of them, who brazenly, with ignorance, just speak upon this stuff and act like this is how it works. There's no, a beneficiary has no power. So let me give you an example. In ancient Rome, there's a term called beneficium abstinende. He who abstains from being the heir becomes the beneficiary, okay? Or he who collects the benefit abstains from being the heir. Beneficium abstinende. Now, if you were going to inherit an estate with a ton of debt, and it would just, it'd be not a very good idea to inherit that estate. So what you could do is instead give administrative control to the estate over to, say, Caesar or Rome or whatever the case may be, right? The government, because it changed forms of government over time. But it's always been equity. And anyways, and then you would agree to collect a benefit. By collecting a benefit from your estate and allowing somebody else to control it, you are entitled to nothing from that estate. You have no control over that estate, and you're entitled to nothing but the benefit. Okay? So now, before I explain what they've done here in this country, there's one more aspect of law, the history of law, that's important. I'm really crushed for time. Obviously, an hour is not enough time to go through all of this, so I'm going to try to give you the points, the high points of it. So, you're entitled to law unless you contract yourself into an indenture. Sure, say you were an Irishman in the 1700s and you wanted to come to the colonies, but you didn't have anything. You wanted to start your life over new. Well, what you could do is you could enter into a contract with, say, a ship captain. And you could say, I agree to labor for 5 years in exchange for a voyage to the colonies. And the ship captain would go, okay, great, that's awesome. So you draw up the contract. That contract becomes commercial paper. It represents the value of the voyage, but doesn't become valuable until the voyage is complete. And it also represents 5 years of your labor. All right? So now the ship captain has this commercial paper. Say it takes 6 months to get to the colonies. So you're laboring for the captain as a deckhand, and now there's 4 years and 6 months left on the contract. Now the ship captain isn't going to keep you on the ship for the 4 years and 6 months. You wanted to get to the colonies, and that was this commercial paper that represents the value of that voyage. And he goes to, say, a plantation owner, and he says, hey, I've got this trust indenture here, right? It's 4.5 years of labor left on it. I want you to give me the value, and I'll give you the commercial paper. Exchange. Now, whoever holds that commercial paper has title to you, not just your property, but you, your sweat equity. You are entitled to none of the fruits of your labor until that contract expires in 4.5 years. And whoever holds that contract can pretty much tell you to do whatever. So, especially back then. So, he sells it to the plantation owner. Now, the plantation owner obviously uses it, the ship captain gets his money, and everybody's happy. But what was happening that created the problem with the Irish indentures is they started coming up with these clever ways of extending the indenture. Well, I am feeding you, I am housing you, I am clothing you, right? Those all cost money. So we're going to tack that onto your indenture. That's how they started abusing that. So that's one way you can end up in the position we are in right now, because that's the position we're in, is a trust indenture with no end date as long as Federal Reserve notes continue to be issued. That's a fact. And I'm going to prove it. Anyways, the other way you can end up under administration is something called presumption of incompetence. Okay? So I want to show you guys something, and you guys are really going to appreciate this, I hope. Anyway, by the way, if I haven't mentioned, if you ever endeavor to study law but you're an atheist, you're not going to get anywhere. Just so you know. And I'm sorry if that offends you, but it's true. And I'm going to show you right here. This is called a treatise on the American law of administration. Now, remember what Blackstone said. In order for laws to have any force or validity, they have to be traced back to the original law of nature. All right? So, actually, let's go there first. I think that is 47 in Blackstone's, page 47. Bear with me, I didn't want to pull up multiple. No, it's not, it's up higher. It's more towards the beginning. Right here. All right, so read this. It's very interesting. It says, I'm trying to see my cursor here. Let's put that back up a little bit. All right. Anyway, man considered a creature. What's a creature? Something created. Now remember, this jurist, this guy, Sir William Blackstone, if you don't know, he's cited by Supreme Court justices to this day, and lawyers, and giving opinions all throughout the 1800s. They cite Blackstone, okay? Because Blackstone was considered the ultimate authority on law at the founding of this republic and all the way through the 1900s and even up to this day. So it says, man considered as a creature, something created, right, must necessarily be subject to the laws of his creator, for he is entirely a dependent being. This is how you can get pulled out of common law and be presumed to have no will, is through dependency. So dependency creates ability. You're automatically subject to the law of nature, nature's God, because you can't survive without God. And whatever you cannot survive without, you have to conform. If it's an intelligent entity, you have to conform to its will. Okay? And he says that. So because we're all dependent on God and have no choice, that's why God's will, God's law applies to every king, the Pope even. There is no high enough office of sovereign for God's law not to apply to you, because you couldn't exist without God. All right? It says a being independent of any other, meaning other than God, has no rule to pursue but such as he prescribes to himself. That's called being sovereign. So you still have, as a sovereign, to follow God's law, but you don't have to listen to anybody else, because who the hell are they, right? I do what I want as long as I don't hurt anybody. And then he goes on to say, after that, but a state of dependence will inevitably oblige the inferior to take the will, and note, you're going to hear this word a lot in my presentation, will, free will. Okay? That is, your body is just the vehicle of free will. We'll get into that. But a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. So, the Magna Carta was a huge trick. Shortly after they established feudalism, William the Conqueror split the courts. Prior to William the Conqueror, and we do have to go back to history for this to make sense a little bit, prior to William the Conqueror, England was self-governing. Even with the king, they were divided into what was called 100 courts, and it consisted of approximately 100 families, where the men of those families would get together, recite the law, and settle disputes between the families. Another interesting thing is, the law was not written. It was considered by our ancient ancestors to be an abomination to write the law down. It didn't need to be written. Everybody knows the law. If I take something from you without your consent, if I harm you, I've broken the law. It's that simple. If I dishonor my word, I've broken the law. All right, it didn't need to be written. So they would recite orally at these gatherings, these 100 courts, they'd recite orally the law, then the men of those families would settle the disputes, sometimes even by trial, by battle, which is a whole thing. But anyways, the point is, if it was an egregious enough thing, that was on the table. But they were self-governing. So William the Conqueror, they would also hear spiritual matters in these 100 courts. William the Conqueror didn't like the self-governance. So immediately what he did is he let them keep their common law, he split their courts and said, you know what, I'm going to give the spiritual matters over to the priest class of Rome. Now, I'm not trying to throw the Holy Roman Empire under the bus too much, right? But you can't talk about this stuff without bringing up the fact that they are still trying to conquer the world to this day. This entire trust indenture system is just the realization of unum sanctum, the one world trust. And that's why the Rothschilds, if you look up in the Jewish Encyclopedia, are still guardians of the papal treasure. In fact, let's see if I can pull that up real quick. We get Jewish Encyclopedia, there you go, and under Rothschild, and then we do Control F, great research tactic, by the way, and we say papal treasure. So it only occurs 5 times, and we'll go down, right here. All right. says right here in this fluff piece, which it is for the Rothschilds and the Jewish Encyclopedia. So everybody wants to blame one or the other, right? It's Israel, it's the Jesuits, who is it, right? Well, it's both. It's both of them. Okay, it always has been. That's why the Pharisees and the Sadducees would have dinner at the houses of the Roman Pilate and all the leaders in Roman-occupied Jerusalem, because they work together, they have worked together the entire time. It's not one or the other, it's both. And honestly, it's neither, because it's not Jews or Catholics. Your average Jew and your average Catholic are very good people generally. You know, they have their flaws. It's actually what has infected the government of these two cultures, if you want to call them, you know, that, these two religions. And that would be the ancient Babylonian sorcerers that use money magic, contract law to trap you in a trust indenture. So I don't have time to get into all that, but you see this right here. It says it is somewhat a curious sequel to the attempt to set up a Catholic competitor to the Rothschilds, that at the present time, the latter are the guardians of the papal treasure. The papacy is in control of banks, all right? But let's get back to what we were looking at. So, a state of dependence will oblige the inferior to take the will of whoever he depends on, essentially. And so, William the Conqueror, immediately what happened was, you had this body of law fleshed out about what is of age. When is someone determined to be able to manage the affairs of their estate? Okay, well, you got to remember, right after, well, you probably don't know, right after William the Conqueror conquered England, the Holy Crusade started. So you had all these barons and knights and all these people who held title in England going off to die in a holy war for the church, right? In the Holy Land. Well, what would happen is, so spiritual matters, ecclesiastical laws, what's called ecclesiastical court, determines death, inheritance, marriage, tithing, stuff like that. That's what the priest class was given charge of. So when these knights and these barons and people would die and their heirs were not of age, they got taken under administration because they did not have free will yet. And so the priest, while administering the estate, would start selling off the property and lining their pockets with the heirs' inheritance. And the barons ended up getting so pissed off about this that they cornered King John at the battlefield near Runnymede and forced him to sign the Magna Carta, which was the Great Charter of Liberty. This trust system that was set up started putting common law into disuse because of equity, right? Started putting common law into disuse, and it would have been buried, because they can't get rid of it, if not for the Magna Carta, which enshrined it. The first 5 articles in the Magna Carta deal with inheritance and administration, but it's a double-edged sword, because it also infected common law with Roman trust law. So throughout the Middle Ages, I'm not going to bore you with too much more history, but throughout the Middle Ages, all the way leading up to the creation of this republic, they started increasing legislation that allowed them to take people under administration. We have the poor laws of the 1600s, which you're under right now, by the way. The settlement laws of the 1600s, which you're under right away. Your birth certificate is a settlement certificate and a warehouse receipt, depending on which jurisdiction you're talking about. And this, of course, the Set to KV Acts, which culminated in the Set to KV Act of 1666. So let me explain this, the state of dependency. If you're an infant and not determined to manage the affairs of your estate, and this is something they've taken, this is a great example of common law, how it's observed and not written. They observe this, they say, okay, we're dependent upon God because we can't exist without God, and therefore that is why we're subject to God's will. Well, this pauper, this poor person, or this infant, this minor, who cannot take care of themselves, must necessarily conform to my will in the same way that I must conform to God's will, because this creature cannot survive without me. That's what led to the legislation of the Poor Laws and the Settlement Acts and the Set the KV Acts, right? And this was incremental. It was a step-by-step march towards the digital prison they're building today. It sounds crazy, but I almost feel like the technology that that drives AI was not invented, it was given. But that's just my theory, and I don't present theories often because I can't prove them. I just present what I can prove. That's what I pride myself on. So, that's just my opinion of dark forces behind this stuff. So, they say this pauper must necessarily come under my administration. Well then, they started engineering poverty. Okay, they passed a series of forestry laws that pushed everybody out of the villages and the forest off of the land they could survive on and into the cities to work for the merchant oligarchs. Obviously, when they were forced by statute off the lands, they were poor, and they came under administration. That's how England converted its citizenry to property. And when it comes to the colonies were under the same administrative law via the companies that settled it. Okay, so there's so much to this that I can't possibly get to it, so I'm trying to say the main points, but it's even papal bulls, like the Doctrine of Discovery, led to the birth of the companies, like the Virginia Company, well, the East India Trading Company in 1600, the Virginia Company of 1606, right? And these companies ended up becoming the governments of the colonies when they became independent. And it was all under the Doctrine of Discovery to go conquer the heathen lands and subject it to the church. That's what it was. And so these companies had a financial interest in the colonies. So they were literally, it's important to note, these companies, the forerunners to our corporate oligarchy today, were like portable governments, okay? Like the East India Trading Company had its own military, its own set of laws, well, statutes, right? Everything all under admiralty, of course. And then they were able to impose that upon the colonists. I'm not going to get too much into that, but suffice to say, when we won our independence, it was for two reasons. One was the fact that they were being subjected to a foreign and unwarrantable jurisdiction that was not common law. It was admiralty courts, all right, international law, international maritime law. And the second reason is because the Bank of England, after it was established in the late 1600s, immediately started causing Parliament to impose, like, essentially taxes that are just as bad as income tax and property tax today, right? Actually, not even as bad if you want to get technical. And the colonists started printing their own currency. So basically, they ran out of materials to make the English currency, and they were like, okay, well, what are we going to do? Well, Benjamin Franklin, he said, why don't we do this? We can just create our own script, colonial script, and it will have no interest on it like the English, like the Bank of England currency does, and we can print it in just the right proportion to facilitate and stimulate the economy without inflation or deflation, right? Within a year, the colonies were more prosperous than almost anywhere else in the world. So much so that the Bank of England, and this, interestingly enough, the U.S. debt clock, how many of you know about the U.S. debt clock? Ready to show of hands. Okay, yeah, just recently they had a PDF, they still have it in the secret window, you can download, that actually detailed, not as extensively, it doesn't tell you who did it like I am, but it tells you what happened, and it's trying to get you to believe that digital currency is a good thing, so it's really a trick. But anyways, it was so prosperous, it caught the attention of the Bank of England. The Bank of England sent a delegate over to speak to Dr. Ben Franklin, and he said, wow, you guys are really booming over here. Not verbatim, obviously, it's my own vernacular, but he said, you guys are really booming over here, what are you guys doing? He said, oh, well, it's quite simple, actually. We just started making our own money. You know, we started making our own currency, and we can do it in just the right amount, stimulate the economy without interest, right? Without any kind of stuff like that. So the delegate from the Bank of England went back to the Bank of England and said, hey, this is what they're doing. The Bank of England immediately went to Parliament and said, you got to stop them right now. And so the Parliament passed the Currency Act, which said not only can you not use script, but you have to pay all of your taxes to the king in gold. So what happened is these business owners that had just made a bunch of money with colonial script had all their assets tied in colonial script, right? All their wealth tied in colonial script. That script just became worthless overnight, immediately worthless. They lost everything, okay? Not only that, but they still owed the taxes, which could only be paid in gold. So suffice to say, they said, get paid, right? Come get it. Come get it. That was the cause of the Revolutionary War. Dr. Ben Franklin, in his autobiography, said, the colonists would gladly board any tax on tea or any other item if it were not for King George and England and Parliament taking away their ability to control their own currency. Well, look where we're at today with the Federal Reserve, right? That was the reason this republic was founded, and that's why you were sovereign, and that's why there were all these safeguards put in place to protect you from a feudal system under a central bank. Karl Marx said, in order for communism to exist, there must be a central bank. Why? So that you can collateralize the people of a nation if you can bring them under your, because all governments are corporations anyway. I don't know if you guys know that, but that's the case. It's a form of a trust. And so you can bring all your citizenry under the umbrella of your corporation and then collateralize them as capital stock. right? And then borrow money against their future productive value, in essence mortgaging them and creating a trust indenture. And now all of their property, including themselves, they're held in trust as collateral for the public debt, and they're under administrative regulation. It's quite interesting. So that was the cause. Now let's discuss property a little bit more. Let's see, where am I at? Oh man. Hopefully I get a couple extra minutes because we started late. All right, so let's go over this real quick. Not this, Treatise on the Law of American Administration. So this is a treatise on the American Law of Administration. It's written by J.G. Warner. It's a treatise from the 1800s. Forgive me, I don't remember the exact year, but it's an excellent treatise. And just like Blackstone's debt, he had to trace administrative law back to the original law, which we just did, which I just explained to you. So he does this very well. He says, my property is that which is mine. It's mine, right? Think about that. Think how primal that is. What does a child do when another kid comes up and tries to take their toy? What do? Mine. It's mine. Mine, right? So that, and here, let's highlight this. That only is mine, which I acquire, didn't mean to get a new mouse, acquire, hold, and dispose of by my will. It is my will which determines the acquisition of the thing. By me, whether originally by reducing to possession and thus making my property that which was no one's property before, or by contract, by which a thing becomes mine through the concurrence of my will with the will of its former owner, is what he says. Now, look at what he's saying. Property is the ultimate realization of your will. And what is free will? Who gave you that? Can you even quantify or explain free will? What gives you the ability to choose? What gives you the ability to be unique and individualized in your selection of clothes, your selection of an automobile, your selection of a mate, right? What is that? Right? It's not substantial. It is that part of us that is made in the image of God. Is our will, our free will. Now, he says that it is my will which determines the acquisition of things. That means that everything that you get, you decide to make your property through your labor, is an extension of your will and the ultimate realization of your will, right? So let's continue. He says, since I cannot rightfully acquire the property of another without his consent, that is, without his free will, it is obvious that the will of the original owner is a necessary element in my ownership, and in my ownership of anyone, or in the ownership of anyone who may lawfully acquire it after me, remains operative until the property has lost its character as such by voluntary abandonment. That's where you get all the abandoned property laws in common law, right? There's a whole prescription for how you're able to consider property abandoned. You put a notice on it. I'm not going to get into it, but that's why. It's because you can't violate another person's free will. So he goes on to say, let's see. He says right here. This is it. I hold or use a thing which is mine at will. Matter is unfree. It has no will. Why do you think they reduce you to property? Right? Now you just become material, matter. You're unfree, you have no will. It does not belong to itself. Neither right nor duty can be predicated of a mere thing. Its quality is to offer resistance. It is therefore negative to my will, and then realizing itself overcomes this resistance and subjects the thing to its purposes, changing its form, destroying and consuming it. I'm going to get a little esoteric with you guys real quick. The knowledge of good and evil is the knowledge of the interplay between the positive and negative polarities, in my opinion, because who am I, right? But that's what I observe, and how it applies from the micro to the macro. It takes a positive and negative to create an energetic circuit of a battery. You've got one side with a nub and you've got a flat side. You connect the two, you have an energetic circuit. It applies to human society as well. In order for a contract to be valid, there has to be an equal exchange of those polarities. You have to give something, experience a loss, right, which would be positive. You're giving forth something. You have to receive something, which is negative. Not negative like how you probably have been taught to think, but just meaning receptive, right? He's showing a deep understanding of this in how property is acquired, because the inherent nature of the property is to offer resistance. And your will is the positive aspect of this, overcoming the resistance, making it your property. But I'm not going to bore you guys with that too much. It does get very spiritual, though, when you talk about the law. Because when you go down here, talking about the operation of the owner's will after his death, he says, "For the sphere of the law is the spiritual. It operates upon and through the will alone. Thus the law recognizes in property of the deceased person his free will, and that is his rational will, and enforces it. The spirit of the law is the spiritual because all rights are derived from property. All property is acquired by free will. And what is free will? If you could answer that, you'd be rich, right? Absolutely God-given, Mojo. That's right. Mojo, he's a subscriber to Burn the Corporate Fiction and a member of the Jury Society. He knows exactly what I'm talking about. So there is one little other thing I want to show you just to validate what I told you about William the Conqueror. I actually just came across this in this book the other day because I picked through this book, but it's section 11, I believe, or section 12, sorry. And you go down here, section 11, section 12. Okay. So it says, such being, you're like, why did you bore me with this history of feudalism and all this stuff, right? Well, this is what Warner says. He says, such being the logical basis and scope of the courts having control of executors and administrators, the historical development in England, but more particularly the United States, has been a gradual but steady separation from the common law and chancery courts, and has resulted in a practical recognition of probate jurisdiction. Everything is probate right now, as a distinct and independent branch of the law, destined to achieve by its own inherent principles, right? Then, he says right here, he says the importance of the division between personal property and real property grows out of, or is at least enhanced by, the introduction of the feudal system into England after the conquest, William the Conqueror, he says, which put an end to all absolute ownership in land, and thus did violence to the principle upon which property rests, which is free will. How could the king take control of all the property? Well, he didn't just take control. They freely gave it, as Blackstone says. Don't have time to get into that one. But essentially, let's fast forward to what's happened, because we're running short on time here. And if you're interested in learning more about this, subscribe to Burn the Corporate Fiction. I'm on YouTube, Facebook, and Rumble. And I do open panels regularly, so you'll be able to come up and ask me any questions if you have any. Burn the Corporate Fiction. Also, if anybody's interested in a copy of these documents, or other documents, or has any questions, email me at burnthecorporatefiction@yahoo.com, and I'll be happy to answer it. We just simply don't have enough time to go into everything. And I hope you all appreciate that. So, now I need to open another file. For some reason I didn't bring it up, but this is pretty much the most important thing, so I'm surprised I didn't bring it up. But we'll do GPO. And this is directly from congress.gov. Okay. Directly from congress.gov. All right, this is House Congressional Record, March 9, 1933. So I'm going to give you a synopsis. What happened is the people created the states created the federal government got crafty and created its own creature called the United States citizen. The 14th Amendment was ratified in 1868, and it is a trust office. It was created for the newly freed slaves. It does not entitle you to any rights. You get privileges, immunities, benefits, and protection in exchange for not questioning the public debt. The reason they did this is because the federal government was given the power over currency, but no power over the people of the state. And the plan had been the entire time to establish a central bank, just like the Bank of England, and indenture everybody to it by collateralizing and mortgaging them. But they couldn't do that to the people of the states because the people of the states were above even the state governments, and the state governments were above the federal government because the creator can never be subject to the created. That is a maxim of law, right? So they got crafty, engineered the Civil War through various secret societies, Jesuits, etc., which Abraham Lincoln spoke at great length about. He said, it's not against the people of the South alone that I fight, but against the Pope and his insidious Jesuits and their bloodthirsty, blind, obedient slaves. That is an Abraham Lincoln quote from the 50 Years Under Rome by Charles Chiniquy, who Lincoln actually got off of a criminal accusation. The Jesuits had set him up. Anyways, not going to get into that too much, but they instigated the Civil War. After the Civil War, the federal corporation had successfully established dominance over the states. See, the states are their own country. That's what most people, they don't understand that all states are confederate, and the states were individual countries that agreed to be in a league of friendship with the other countries for mutual economic prosperity and defense. But, as Penhallow v. Stone's administrator says, right here, it says, let's see. Well, I'll just tell you, it's in here though if you guys are curious. It says, when a union is confederate and not corporate, right, the sovereignty resides within the state, right here. Yeah, look, I found that pretty quick. All right, so it says, but whenever alliance is not corporate but confederate, the sovereignty resides in each state, okay? And he says that, now the state retained all powers which she did not expressly surrender to the Union. The state cannot cease to be sovereign without its own act, nor can sovereignty be asserted but upon a clear title. What do we call the portion of the federal government that deals with foreign nations? Department of State, because a state is a country. We call England a foreign state. Italy is a foreign state. Marco Rubio deals with foreign states. All states are sovereign, all states are independent countries. If you live here in Arizona, you're not a United States citizen, you're an Arizonan. I'm in Michigan, I'm not a United States citizen, I've claimed my state on the record. I'm a Michiganian, that's where I was born, on the land, Michigan. I'm a Michiganian, okay? I stand above, now the 14th Amendment citizen is a trust office, right? So you go to Dow, let's see, Maxwell v. Dow, right here. This is 176 U.S. 581. He says, the privileges and immunities of the citizens of the United States do not necessarily include the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Now, how could that be? Well, that's because they have no common law rights. They have privileges and immunities because they are an enfranchisement of the federal corporation. They owe their whole existence to the corporation, and they thereby give administrative control by signing up for U.S. citizen. You give administrative control of your estate. 1933, after they had gotten a majority of people to adopt United States citizenship, and which is a trust office, which I haven't even been able to explain to you because it's all about equity, and equity is shared interest in property determined by contract, so you become property under shared interest with the federal corporation, and all of your properties under administration only have access to a court of equity where the judges got. Now that's going to confuse you. Watch my channel, and it'll make sense. I do many shows on the difference between law and equity. Right now you only have access to a court of equity because all of your property is held in trust. Equity deals with fiction. It is not law. The Article 3, Section 2 distinguishes it. Right? The judiciary shall have jurisdiction in all cases of law and equity, something like that makes a distinction because equity is not law. Because it's not law and because it deals with fake things, the judge is allowed to be God. You don't have a trial by jury because it's not supposed to be dealing with living people. That's how you can have bench trials. Now see, because equity deals with fictions, it can also do things like injunctions and stop somebody from doing something in the future, where law can only recognize what is and what has happened and nothing else. You cannot recognize fiction. So you can only have a DUI in a court of equity, by the way. You're punished, and I'm not saying I agree with driving drunk, I totally disagree with it, but in a responsible republic of sovereign people, you would know better than to do something stupid like that, and the government wouldn't have to be your parent, so there's that. But when you get a DUI, you're being punished not for what you did, but for what you might have done. See, pre-crime, this AI pre-crime system that they're setting up, because you're locked in a trust indenture, can only exist in equity, can't exist in law. They're trying to bar your access to law forever with the digital ID and the digital currency and AI government. Like I said, so they can get rid of due process. But right here, this is how they did it. They said in 1933, after they had most everybody under the 14th Amendment as administrative warrants of the corporate state, they were then able to mortgage them. Okay? It says right here, as soon as I can see my cursor again, there it is. Okay, it says the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. They mortgaged your property rights. They mortgaged your estate to the central banking cartel. Shortly after this, they created the Social Security Act in 1935, which essentially created a public trust account. And now, all your registrable property your automobile, your boat, your land, your child, is tied to this public account to be held in trust as collateral for the public debt and under administration. Last document I'm going to show you guys real quick because it's all I have time for. If you're interested in asking me questions, because there's probably a lot of questions you may have, holes that I was not able to cover in a short amount of time. Streams generally run 2 hours at least, but this document right here is called Fiduciary Foundations of Administrative Law. It is a UCLA law review. Law reviews are admissible as evidence in court. That's how serious they are. They're not just like some opinionated article. This is an analysis of the system. And this is called Fiduciary Foundations of Administrative Law. Now, a fiduciary is a trustee that can make financial decisions on behalf of the trust. The judge is acting as fiduciary when he's trying to dispose of a traffic ticket. Right? Dispose means what they do is they create an attachment to your trust via your license plate or your driver's license number or whatever identifying number that's linked to your social security number. The pirate, the road pirate that they call a police officer, he's a road pirate. He's literally committing piracy. It's inland piracy. There's no other way to put it. I'm not even being a jerk. I'm being objectively serious. It is inland piracy. Creates an attachment to your trust, right? Your social security trust via your driver's license, whatever. Then he uses that as security, right? As collateral, essentially, to generate the court, so the court can generate its own commercial paper. And that is the traffic ticket, court fines, bonds, stuff like that, right? The thing is, in 1933, when they mortgaged your estate, like I just showed you, they switched the currency to debt. Now, it's not money. It represents something owed in the future, and it's secured because all contracts, all mortgages like that require security. When you take out a mortgage, the land is the security. You're the land that is the security for the mortgage I just showed you. The security is your future sweat equity, your labor, and the ability to control you and generate commercial paper from your use of your property, which is what they do. So when we read this, the emerging fiduciary model in administrative law posits that administrative agencies are endowed with authority. What are administrative agencies? Well, those are your three-letter agencies. Your EPA, your IRS, most importantly for us in everyday life, the DMV. That's an administrative agency, okay? Administrative agencies are endowed with authority to set regulatory policy. Well, what is regulatory policy? Building code, motor vehicle code, revenue code. They're really all just revenue codes, though. They fall under the definition of revenue code. Motor vehicle code is a form of revenue code because it's meant to generate revenue. What's the cop doing? Generating revenue. So, to set regulatory policies, such as the motor vehicle code, when Congress and the President acting jointly as proxy settlers for the sovereign people. So I'm just going to show you this real quick, and then I got to get off here, but we're going to look up in Bouvier's Law Dictionary. Okay, and we're going to look up the letter S. So we'll just click this, we'll go up here, and I apologize for not having it prepared, but it's very important that you know what settlement is. All right, so we're going to go down to settlement, which is right here. The conveyance of an estate for the benefit of some person or persons. So they mortgaged your estate, they conveyed it to the central banking system. What are the benefits you receive? Well, you get a retirement benefit, deferred retirement benefit, Social Security. You get the benefit of the space agency, which is under Title 42. See, everything they appropriate, yeah, real big benefit, right? Everything they appropriate has to be under the guise of being a benefit for you because you're an infant pauper under administration as a U.S. citizen, but you don't have to be, okay? You don't have to be. It tells you right here that they acted as proxy settlers. Now, you're held in trust, all your property's held in trust and subject to the regulation of these administrative agencies. What you can do is, first of all, learn what they're doing to fight them, because I don't bring problems without solutions, and I apologize for not being able to get to the solution portion of this, but you claim your estate on your county record, right? And you expatriate from 14th Amendment citizenship, which you 100% can. Right here, this is actually what I was saying, sorry. It tells you right here, this is McDonald v. State, Indiana Supreme Court, whenever it loads, there we go. And it's from 1883, just after the 14th Amendment, And so a guy got convicted of a crime. He appealed the crime, saying one of the jurors is not a United States citizen. Therefore, that jury should be, nullified. It should be void, that jury decision. So they denied his appeal because they said the evidence of bushing on his voir dire, which is a competency examination for a juror, showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. We need to get rid of 14th Amendment citizenship, ladies and gentlemen. And that's my time. I appreciate everyone for being here and listening to some dry, boring law history. If you have any questions about anything else, see you later.
Get tickets to this year's event at internationaltruthexpo.com.